My lords and my lady, my name is Okiya Omtatah, the first petitioner in petition 181. I adopt my submissions of that 1st August 2023. At section B, paragraph 6, I've given a list of the documents I rely on, and an extra document that is not included is the petitioner's response, my response to the written submissions opposing the petition, and it is dated the 7th day of September 2023. My lords, pursuant to Article 10, policy, Article 10, Article 165, 3D2, and Article 2, policy decisions are subject to judicial review. We have a prescriptive of the Constitution that even if it's a policy decision, it must be done according to the Constitution. I also submit that any bill touching on the Bill of Rights must be considered by both houses of Parliament, because even the county governments are subject to the Bill of Rights. Taxation affects property rights. It's also an administrative action under Article 47 and Article 40 respectively, and it must be subjected to consideration by both houses. In my submissions, I'll look at the other part of the petition. The petition was really in two parts. And I will highlight my submissions concerning the procedure for making the budget before we go to the finance bill. And it's my submission that Article 220, Clause 1, Paragraph A, defines what a budget is as a document that contains both revenue and expenditure. Now, when you come to this particular process we have had, and Article 221 gives the procedure for how those estimates have to be introduced in the National Assembly. Because it's a money bill, it has been introduced in the National Assembly pursuant to Article 109, Clause 5. And then those estimates also contain the estimates of Chapter 15 entities, which under Article 249, Clause 3, the Constitution expressly requires that Parliament, and when the Constitution uses the word Parliament, it means both houses. If it means one of the houses, it uses the name of the particular chamber. Under Article 249, Clause 3, it states that Parliament shall allocate adequate funds to the Chapter 15 entities. So it's my submission that since the estimates submitted under Article 221 contain estimates of expenditure of the Chapter 15 entities, it naturally follows that the procedure under Article 221 must be read with Article 249, Clause 3, and that would ensure that as per constitutional edict, the budget must be considered by both houses. In my submissions, I've also shown that after there were no estimates of revenue that agreed with Article 221, Clause 2B, that was submitted to the National Assembly. The document that are referring to as the estimates was not in the prescribed form under Section 38 of the Public Finance Management Act. So, I've submitted that the failure to involve the Senate in the consideration of the budget estimates and Appropriation Act violated Article 249, Clause 3, and that voided the entire budget-making process, not just the finance bill. The estimates, the Appropriation Act, and anything that was done under the budget process in the 2023-2024 budget cycle. in Parliament. It's also important to note that Article 96, 1 and 2 are very clear. And 91, the word is not to promote. The Senate is there to protect. So the question should be, why protect? And the only time the word protect is used in the Constitution is in that particular clause. Even in clause 3, it's not as much. It's also used there, but does not have the same connotation. To protect devolution. So we must look at the objects of devolution, including the equitable development of the country, and take into mind that the budget is executed in counties, and it falls upon the Senate under Article 201 and Article 174G to ensure that there's equitable development of this country, so that the national budget is not just done and then maybe all the resources are taken to one side of the country. That would defeat the objects of devolution. And that one requires the involvement of the Senate totally in the making of the budget. Because, my lords, as you know, that the government basically has one policy document. If it's not in the budget, it doesn't exist. So there's no way the Senate can be a bystander in the budget making process if the objects of devolution are taken into account. Also, I've also submitted that the failure to include, to enact the estimates of revenue, I'm assuming that they were introduced in Parliament. Yes, they have argued that they introduced the estimates of revenue in Parliament, but then they disappear. Even the report, which is titled Report of the Committee on the Estimates of Revenue and whatever, do not have any word on the revenues. It only deals with the expenditure. So, my lords, the question that comes to mind is, where did the revenues of estimates go? And under Article 9, 109 clause 1, Parliament exercises its legislative authority through bills approved by Parliament and assented to by the President. We cannot introduce budget estimates through reports of Parliament. That's not how Parliament works. We do a lot of work in Parliament, reports, statements, motions, but Article 109 says the legislative authority of Parliament must start as a bill. And there is no bill that contains estimates of revenue that has been produced in this court. Further, my lords and my lady, I say that the failure then to enact those estimates of revenue into law means that this budget has got no revenue provision. And therefore, why do you need a finance bill? What will it be? A mechanism of raising which revenue? Raising revenue that has not been approved by Parliament? My lords, I also go, and still under 121, clause 6. There's an interesting design in clause 6, whereby the drafters say that the estimates of expenditure of the national government, of the judiciary, and of Parliament shall be included in the Appropriations Act. It does not say they will form the Appropriations Act. What is to be included is to be added on to something else. And so the argument that the Appropriation Act only carries estimates of expenditure of the national government, of the judiciary, and of Parliament is not acceptable under Article 6. They are included in something else. But if you look at the Appropriation Act of 2023, it only has estimates of expenditure. There are no estimates of revenue. Then you go back, and we are told under Article 220, clause 1, paragraph A, that the budget has two components. It has got revenue and it has expenditure. So if the Appropriations Act only has expenditure, where are the revenues in law? Why are there no revenues in law? And what happened to the revenue, the document titled Revenue Estimates of Revenues, although it was not in the format that the law prescribes, What happened to that document? Why was it hidden from the public? Why was it not subjected to public participation? And under Article 221, there's a clear requirement in clause 3 and clause 4 and 5 that the National Assembly will consider both of the estimates, and both will be subjected to public participation. If you read the report of the committee, the estimates of revenue disappeared. And I will explain why later that has been done. So, my lord, the absence of the revenue estimate makes the budget incomplete. It does not conform to Article 220, Clause 1, Paragraph A. And an incomplete budget is no budget. So as we speak, the national government failed and Parliament failed to enact a budget. There's no budget that's running this country. My lord, I also want to show that the Appropriations Act must be submitted to the Senate. And the reasons are found in the Constitution. If you look at Article 204, Clause 3, Paragraph A, it says that the national government may use the Equalization Fund only to the extent that the expenditure of those funds has been approved in an appropriation bill enacted by Parliament, not by the National Assembly. And when you look at Article 221, my lord, at Paragraph 2, at Clause 2A, it clearly states that these estimates of the Equalization Fund are part of the estimates submitted to Parliament. So, Article 221, has done that. Article 223, Clauses 2, 3, and 5 also underscore the fact that the Appropriation Act bill must be enacted by both the Senate and the National Assembly. And in fact, Article 223 is so good because it refers in some paragraphs to Parliament, in some paragraphs to the National Assembly, clearly distinguishing what the National Assembly can do and what is expected of the entire House to do. And so I'm saying that because the Appropriation Act was not submitted to the Senate, that act is null and void, other than being also void for not containing estimates of revenue, which should be to which the expenditure should be included. My lords, we have also highlighted the fact that there are very clear cases of budgeted corruption in the estimates of the current expenditure that has been given, and those are highlighted out, and those recurrent and those the budgeted corruption, including that involving domestic debts, goes to more than 1 trillion shillings, which, if removed, we don't have to have this punitive taxation that the Kenyans are being subjected to. We have highlighted those things in our submissions. Finally, I will submit that the finance bill, as presented to the National Assembly, as published by the National Assembly, was a bill concerning county governments that ought to have been taken to the Senate, but was not, and that voids the finance bill ab initio in its entirety. Also, the fact that it is anchored onto provisions, onto the budget estimates and Appropriation Act, which themselves violated the Constitution, then it's also void ab initio. So, my lords, with those few remarks, I plead with the court. Just very close, I also want to point out what was not mentioned about the housing levy. The housing levy has been applied in a blanket manner without exempting judges and officials of the Chapter 15 entities from the levy. Yet the Constitution says their salaries cannot be interfered with. during their stay in office. So that particular issue should also be taken on alongside with other provisions that have been put. So it's my submission that in its entirety, the budget making process was flawed. And as we say, a river does not flow higher than its source. The Finance Act cannot survive the infringements that preceded its introduction into Parliament and that accompanied it in the process of being enacted. So we pray that you void the Finance Act, you void the Finance Act, you void the Appropriation Act, the current Appropriation Act, the current Finance Act, and also you void the estimates in their entirety for violating the Constitution. With those, thank you very much, Your Lordship. But we had prepared, my Lord, last time. You know, you had given a directive that each petition would be given 10 minutes. And though we are appearing on the same petition, it's just that we had a meeting on mind, so people had different issues. You have submitted on a quite different issue. So everybody submitted submissions in his area where he contributed to the petition. It was not a petition by Omtatah and I invited others. It was a petition whereby people who meet away from alcohol but over tea caucused and agreed that they would do. So as you'll notice, everybody submitted on the area where I contributed. So I'll really be pleading with you that you allow the remaining...
they will be allowed, but until 1:30. That's fine.
Most obliged, my Lord.
Yes. Eliud Karanja Matindi.